substantive seminar, and this is trademarks 1. Before we get started, are there any questions? Oh yeah, and before anyone asks me about a formative, yes, you are getting one. Most likely tomorrow, but possibly on Monday. But are there any questions about the course so far? This goes especially for people who might be new, because I think in like the first few weeks there's been some people have dropped out, which is fine, and have gone on to perhaps more exciting things for them. Other people I think have joined. So in particular, if you've joined and you perhaps missed the first or the second class, and you have questions, obviously come and talk to me. Also, if you're new, you should probably know that I have office hours, and they're on Thursdays from 3:30 until 5. But obviously, seeing as you're in class now, you'll probably find it more handy to speak to me immediately afterwards. Okay, why do I have a picture of a Rubik's Cube? Anyone? Yes? Okay, yeah, so, yeah, exactly. This is exactly why it's up there. So, what we're looking at today are the absolute grounds for refusal of registration. And one of the really controversial grounds is whether you can register a shape as a trademark. And this is something that the makers of the Rubik's Cube have been trying to do. And as I found out just this morning, but I haven't been able to look up the actual decision, they've failed in relation to the Rubik's Cube. The argument seems to have been, this has been going on for several years now, but the most recent argument seems to have been that actually this isn't a trademark so much as a shape that gives the particular item its desired technical result. You know how this works, right? You can twist it. So the idea here is that you can't trademark the thing that is actually the good. In this case, the shape is actually the thing that you're trying to sell. So this is why we have an example of the Rubik's Cube, because as I understand it today, its EU trademark has been cancelled. But I sort of literally found out about it sort of 15 minutes ago, so I can't be entirely sure for the reasons, but this seems to be why. Okay, so shapes are just one of the grounds for refusal we're going to be looking at. Actually, before I get on with sort of the substantive part, I think it's worth mentioning that next week is a reading week. So don't show up, use it sort of wisely to do something else. Do an assignment, catch up on your reading, etc., etc. And that leads nicely to, I had a query from a student about 2 points, and the first of which was, last week we discussed some of the material related to green, and I think the Coombe articles that were on the required reading list. So, I should just preface that by saying is that sometimes I get queries that are significant enough that I don't answer them individually, but rather to the class, and this is one of those. And I will put a note up about this on Moodle as well. Do you need to know it, notwithstanding that we didn't discuss it in detail in class? The answer is yes. The reason you need to know those particular articles, especially anything that's on the reading list, is that the arguments in those articles in particular will allow you to make arguments around context for trademarks. So in going back to look at perhaps the particular activities we looked at in class, or in answering the formative or answering questions in the exam, you can be expected to know that material. Okay, I don't actually now recall who asked me the question. Was it you? Wonderful. Does that answer your query?
Yeah, I was just wondering sort of how much we'll be talking about the social context of trademarks.
Oh!
Did we discuss it as much?
Yes, sorry, yes, that was the other part of it. The answer is that it forms sort of the context. You can use that material to discuss the subsequent material in like the substantive sort of technical classes. So the social effect of trademarking. So for instance, when we look at the absolute grounds, which I think was the other point, when we look at public policy and morality, these become quite important. It's perhaps less obvious this term, except in the very broad context of what is the function of a trademark, what is it for, but it will become particularly important, say, next term when we look at trademarks and creative expression. So suddenly all these arguments around sort of the social context of trademark will become more prominent. The second query that I received, which was about public policy and morality, sort of sent me off on a sort of delightful search for material. So I've added in some slides, so I'll deal with that sort of towards the end of the class. And we can have a little bit of a chat about that as well. Okay, so let's start with an activity. We're actually starting with a couple of activities with the aims and objectives thrown in. This is sort of like a hinge activity, I guess, in the sense that it allows you to revise the material you've already covered in the last two seminars, and also sort of looking forward slightly to this seminar around, what will actually be registrable as a trademark. Oh, you might want to close the windows because I think you're about to get soaked. Anyone who's in front of a window? And we all did well to get here before the rain started, I suppose. Okay, so spend a few minutes perhaps in your sort of groups of the people around you, in twos or fours or whatever it is. Here you have, it's basically a dollhouse miniature breakfast set. I mean, this is perhaps not something that's sort of super unusual. Dollhouses require miniature things, whether it's miniature furniture or miniature foods, etc. So the question here is, are there any trademarks? And if so, is their use acceptable? Now, this relates both to the functions of a trademark, which we addressed last week, but it will also relate to our subsequent seminars around what it means to use a trademark. So some of that material you won't have come across yet, but I think you probably have enough knowledge, certainly in terms of the functions, to be able to answer this. So 5 minutes on that. Basically, are they trademark? Is their use acceptable? And to be able to link that back to, what are trademarks for, basically. Um, 1 to 12 scale miniature waffle prep scenes for dolls' houses. Put another way, why have they used the Roller Mills name for their little dollhouse miniature? Mm-hmm.
Maybe because it's so small, I don't know, people wouldn't recognize that it's flour, or what do you call that?
Oh, flour. Oh, I see what you mean. Yeah, so to make it easier.
So they had to put on a name on it, so they knew what it is. For example, in Germany we have like tissues. We call them Zewa, and you don't say "give me the tissue," you say "give me the Zewa." So it's like.
Okay. Yep.
So they know that this is to bake.
Exactly, given that they're making waffles. Oh yeah, I'd forgotten. That's quite fine. Good.
I think maybe it shows how to produce. Maybe they want to show how to produce that, how to run it. Maybe there is some relationship with that. And when people hear meals and people have a feeling of how to produce that and how we have a feeling of hometown, maybe.
Yeah, so actually with both those points, what you seem to be suggesting is that if you're doing a mini scene for a doll's house, you're trying to make it like the big version, right? And one of the ways that you do that on, like, say, a tiny packet of flour is that you clearly demonstrate on it that this is flour in your mini scene. Okay, so we found a trademark. We found why we think that they're using it here. Is this use acceptable in light of the rationales for trademarks? Someone from this side of the room. Yes.
So one of the functions is so it doesn't really come from the trademark owner, and it doesn't show any quality either in real life because it's just some sort of model. But maybe in the play universe, you would have good quality flower from Roland Mills. So I think it depends on which perspective you take. If you're a child or someone who just has models of fiction, it might be nice, but maybe when it's done without the permission of the trademark holder, they might object.
Yeah, and actually in practice that's exactly what happens. So notwithstanding that it's on a toy, you may still find that the trademark proprietor objects. So this exact scenario came up in the Ortec case, and this was, well, are you using a trademark if you reproduce an actual car as a miniature car that has the tiny trademark on the front of it? So the question then becomes, well, yeah, how are you using it? From the perspective of the trademark proprietor, they may well argue that, well, if someone sees a little bag of flour or the little toy car, they might think that we have expanded into toys. And this is saying that we are the originator both of the actual car and the actual flour you can use to make actual waffles, and the toy, which you will now use in your doll's house, or that you might that your kid might play with, which is the toy car. So, given that in both those instances, both in the Ortec case and here, we have an exact replica, does it seem acceptable that you would do this? Are you using it as a trademark? So we're shifting a bit sort of to infringement now, right? But does it seem acceptable that you should be able to effectively miniaturize something? So just following on from precisely your comment.
Let's say they sell all of this in a big packaging. I'd say it's not an infringement because it's not just about the flower, it's about the whole thing. But for example, if they would just sell the flower like as a miniature, then I'd say this is trademark infringement. But here it's not about the trademark itself, it's about the whole thing to make it more realistic.
So precisely on that point about making it more realistic, I think you're more strict than the courts have been in the Ortec case about the proprietor was just like, well, clearly they are using it. But on this point of it being made realistic, the argument has been, well, the only way you can make it realistic is by using the mark, and therefore it can't be trademark use.
That's what I said.
So I had understood you to say initially that...
They use it, but I don't think it's an infringement because...
Right.
They don't use, like the trademark here is not in the middle of the attention. That's what I'm trying to say.
So it's used...
They used it to make the whole game for the child a bit more realistic.
So it's a use but not a trademark use.
Yeah, it's not an infringement. They use it, so I think it's acceptable but not an infringement.
Okay, so it's not an infringement notwithstanding that any affixing of the mark onto a product is use. Right? So this is why I'm sort of interrogating it.
You can't have both?
No, you can. You can have a trademark that's affixed, but the argument then would be that it isn't use of it as a trademark. It
Yeah,
is
that's
simply
true. Yeah.
so it's simply use of it to make it realistic.
Exactly.
Yeah, so this is precisely what the court says in sort of something like the Ortec case. They say, well, is there any other way that you could make the toy car or to make the flower? So yes, I think this is quite right until the next case that comes along and says, actually, you can't make your tiny bags of flour.
I would have said because it still indicates origin, whether or not it's for the actual use, it's still indicating origin, and because there's an implication when it's used for toys over other brands, there's still an implication there.
Yeah, okay, so this I suppose is the counter argument, right? So here we're saying, well, we're starting to sort of bring in the consumer. So I don't know, would it make a difference if the average consumer for this was actually sort of adult enthusiasts? You have this question sort of around Lego, for instance, which was on your further reading. So the idea might be that because you've used it and you've said, unlike with the sugar where you've just said sugar, here you've used an actual brand, so you seem to be creating that link, like in Arsenal and Reed, that it did in fact come from that producer. So these are, I suppose, the two views. On the one hand, you need a realistic representation. On the other hand, well, why do you have it there, over and above all the other brands? Mm-hmm.
But I think like when some parents go out with their child or children to buy toys for them, nobody gonna look at that precisely and gonna say, oh, there's this flower brand inside, I have to buy this one. So I think as long as they don't buy it just because of the trademark, it's not an infringement.
Yeah, so I have to say, if this was the rule, this would make a lot of things much easier. It's like, I used it for my art, and I used it for that. And exactly, because you're right, if someone goes to buy this for their kids, they're not buying it necessarily because they think it's come from that trademark proprietor, right? They're buying it because it's a realistic depiction of someone who's going to make
and also
breakfast.
It's not real flowers. It's just...
Yeah, so...
I mean, there's no likelihood of confusion, actually.
So this will then depend. So this was going to be my next point, which is, well, what class of goods does the original trademark owner have their trademark in, right? So in this case, I'm assuming that they have it for flour. The next classification for food. Now, the question that I will sort of leave open is, would your answer change if they also had a trademark registered in the toy classification? Someone had their hand up here. Not, I think, in relation to that question, but maybe something else?
No, I was just thinking about the argument that you don't buy it because it's that brand, but you just want a toy. But I was thinking, like, if we maybe take a car, a toy car, and, when you're maybe shopping with your children for toy cars, your children might maybe say, oh, I want that, maybe the car toy because my father drives exactly that car. And then people would buy it for the trademark. So I think it's really hard to, draw lines in that area.
Oh, this is interesting. So, and this, in fact, right. So, I've been approaching this from the perspective of the adult consumer of miniature waffle sets and miniature cars. But actually, yeah, quite possibly, if the consumer that we're talking about is actually the small child, it might be that actually our response to it changes. Because, yeah, the child is going to want precisely that logo on it. Yeah, exactly, because it might be that their parent drives the car. Anyone else?
I think you can compare to the Arsenal case because you would think maybe they have a contract with them. This is some sort of advertisement. If this was a miniature chocolate, my kid would want the real chocolate as well. Like my doll is eating this kind of chocolate, I want it too. So the parents are going to be buying that as well. So as a parent, I would probably think that they're advertising to kids' toys.
Yeah. So this issue about sort of bringing it back to Arsenal, this is quite important, and this is about, well, this goes back to sort of what the role of brands is, and what role trademarks play. Where should we sort of, how should we limit the power of the trademark proprietor. And actually, and sort of what you've made me think of in particular, and this is something that comes up in relation to Lego, and also when you think about the Batman tie-in with the cereal, there are so many of these tie-ins and sort of licensing agreements that it is entirely possible that someone's view might be not, again, we're creating a miniature, but this might be a tie-in with the flour company. The way it might be with Lego and Star Wars, or I always get my comic universes mixed up. Whichever the Batman one is, and the cereal manufacturers, in terms of these sort of licensing frameworks, if you like. So this was actually a really good sort of outline of a lot of the different perspectives around this, which is to say, there's not really any clear answer, and part of the reason there isn't one is that obviously we can apply the rules technically, which we will, in relation to infringement and the relative grounds, but it does come back down to what the rationales for trademark protection are, and how tightly you want to regulate what it is that the trademark proprietor gets when their sign is registered as a mark. If you're quite strict, it would allow these kinds of uses, I think, quite easily. If it's more expansive, especially let's say this was a famous brand, so this goes back to the L'Oreal case, you might say, oh, actually, people would probably associate it with you entered into some kind of agreement and they've given their permission for you to use this. So maybe sort of think about this one, because I think we'll be coming back to these issues sort of over and over. Yes?
No, I just wanted to say, I mean, you actually don't know if people are going to associate something with the brand. You can just assume that. For example, you don't know if a child wants to drive the same toy car as his dad's actually driving, or it differs from children to adults.
Yeah.
So this is like, it's more about the influence the trademark has.
Yeah.
And this is something you can't do something about that. That's just what happens.
Well, I mean, yeah, so a lot of the arguments in the literature is just like, well, these things are out there as part of the intellectual commons, and all the trademark proprietors should just sort of get over themselves and realize that people are going to use it because they were co-created anyway. What they would say, I suppose, in response to that is that, yes, you're right, it depends on who the consumer is, and we'll spend some time talking about the average consumer in the next class, because it goes back precisely to this question of, in relation to the relative grounds, you don't need to demonstrate confusion, which you may well do in relation to infringement, but you just need to say there's a likelihood that people will be confused. So one way of interpreting this then is to say, well, who is the consumer of this? Are they likely to be confused about where this came from? And then it will sort of depend on your view about, are they likely to think that it's some kind of tie-in? Are they buying a realistic depiction of something that they want? Okay, so bearing this in mind in terms of, what's likely to be registered as a sign and the rationales, today we're moving on to sort of the first set of exclusions for trademark protection. And these are the absolute grounds. In 2 weeks' time, we will look at the relative grounds. I will repeat this several times, and you will have seen it in your textbook reading as well. The absolute grounds for refusal of registering a sign are simply, this is the list of things you can't have, and you're just checking the sign against that list. In the relative grounds, you are checking that sign against earlier rights. So usually earlier registered trademarks or other rights that were there before you tried to register it. So today we're just looking at sort of the fundamental list, which brings us to this, which was on your reading list. And this is quite a useful case. I mean, I imagine some of you perhaps have been to London or are planning to go to London, so this sort of, here as well, as a sort of taxi shape of a car, is probably something that's quite, that you are familiar with. And what I want you to do in this activity, by contrast to the preceding one, is to sort of look at the technical aspects of the judgment. See exactly just ignore passing off. I realize that the last sort of several paragraphs are about passing off. You can ignore that for now. It's quite common to have trademarks and passing off in one case. But apart from that, what was the legal problem and how was it resolved? So, which court is it? What were they asked to address? What were the different aspects of trademark law that they were considering, and how did they resolve them? It doesn't have to be sort of super detailed, but just to know, what is the procedural history of this? What were they looking at? Basically, just to make it a little bit easier, they were primarily looking at 3 grounds of refusal. One of which is probably clear just from the picture. So what grounds were they looking at? How did they resolve it? Which is just basically, how did this end? So, what was this about? What was the legal problem? How did they resolve it? So 5 minutes for that, or maybe a bit longer if you need it. And just see if you can sort of set it out. Perhaps have one person taking notes to set out exactly what happened. in the case. I'm not suggesting that this is the world's most exciting case, but it is relatively short and sort of interesting. So, what did the court decide and why? What I want you to do is to find another small group, and I want one of the groups to identify the legal problem, and I want the other group to explain how it was resolved. You can have 5 minutes and sort of arrange amongst yourselves who wants sort of the slightly easier part of that question. But obviously the other group can make comments. So, try to explain to the other group what the legal problem is. The other group try to explain how it was resolved. This is great for you. For everyone else, you do have to worry about it, but in the other class, where we will talk about these at length. So I should begin then by saying, so I'm quite grateful for this query. There are, roughly speaking, in terms of the type of trademark, we have collective marks. So this is why I put on the list sections 49 and 50 of the Trademarks Act. So you're aware that they're there, but it's not what we're dealing with this term. So a collective mark is a mark that is used basically on behalf of an association that is then put on goods. So it's traders sort of banding together to protect themselves as opposed to it being a solitary trader. A certification mark is similar. You have a particular mark that you enable people to put on goods, basically saying, you know, this is of a particular quality. Now, one of the reasons that we're not dealing with it in this class is that actually the examination rules for collective and certification marks are a little bit different. So there are particular schedules that deal with these in sort of more detail, and the actual process for gaining a registration of a collective or certification mark is different. So I put them there on the reading list to note as the thing that is there as a possibility for something that you might register, but we're not looking at those. What we're looking at instead is like the standard individual mark. So this is something you all need to know about. In particular for this term, we're looking at an individual mark. So when we look at the basics of trademark validity, this is more sort of for noting, right? I'm not actually expecting that anyone's going to remember like all the... I mean, you should know the key sections. You should know sections 1, 2, 3, 5, 10, 46, etc. You know, some of the ones that we'll do sort of a lot of. But when we talk about the trademark basics of validity, we're going to be talking about it in the context of individual marks. So here we have a summary, both of the reasons we will not register a mark. So remember, we're in the absolute grounds now. And also just to remind you, of course, that this is harmonized. So you will see the Trademarks Act 1994, you will see is echoing the Trademarks Directive and the EU TMR. So the EU TMR, this is the trademark regulations. This obviously is for EU trademarks, EU TMs. The TMA is for UK TMs. We're mostly obviously looking at the UK. I know that you're looking at the EU sort of more directly for those of you who are taking the contemporary issues class. So we're going to go through a number of these, some in more detail than others. And the question we're asking at this stage is, do you even have a sign to begin with? So something that you might even contemplate registering. And 2, is it going to fall foul against, in terms of the various absolute grounds for registration? So distinctiveness, as you saw in the London taxi case, distinctiveness, acquired distinctiveness, and shape are pretty sort of typical ones. The other point to note, which is why I think it's quite helpful to have a summary of the main ones, is that very often multiple grounds will come up in one case. Why might this be? It might be, especially if you're the person who's opposing someone else's mark, if you want to oppose it, you want to try to oppose it as much as possible. You don't want to say, you know, I have just this one ground. You want to say, well, there's this one ground. In the alternative, it's these other two grounds, if that's plausible. So it just gives you sort of a better chance of winning. So you saw that very clearly, I think, in the London taxi case, where you use the grounds for refusal as a defense against a claim for infringement. So you get sued for infringement, and you say, well, I couldn't possibly have infringed your mark, because it turns out that your mark was never validly registered. A mistake was made. And it was never validly registered because it turns out it's not distinctive, it has not acquired distinctiveness, and also it's a shape, which is what we see in the London taxi case. So you end up using, you can use these grounds, obviously they're to do with examination at the point of registration, but you can also sort of use them as a sword to defend yourself subsequently in infringement proceedings. So these are what we're looking at today. In a slightly sort of easier way of looking at validity, well, depending on sort of your frame of mind, we're looking for a sign. This is what I mean about step one. A sign that's representable on the register. We'll go through this. And that's distinctive in a sort of very basic way, as in, can you use this and put it, you know, to put it on goods or services. Step two is, does it fall foul of the absolute grounds for refusal, the list that we just looked at? So this is when you're trying to register it, this is how it's going to be examined. And the third step, which we'll look at in 2 weeks' time, are the relative grounds for refusal. So even if you get past steps 1 and 2, the third step will be, well, are you actually trying to register something that already exists? So this is a sort of, I guess you could say, very much an overview. The other point to note here when we're looking at how this is done, again, I've mentioned it, in relation to the absolute grounds for refusal, anyone can oppose it. You know, if you wanted an activity, you could you could go and like oppose things if you wanted. There is a form. It's quite a long form, but you could do it. In relation to the relative grounds, you need to actually be the person who's the trademark proprietor or who is the holder of an earlier right. And that right might actually be in passing off, for instance, which we'll do at the end of the class. So, helpfully, we start with Section 1 of the Trademarks Act, which probably you will have read. You can access it on Westlaw. And here I've basically highlighted in blue the key elements. So here, this is basically step 1. It is a sign. You need a sign. You need something that is capable of being a trademark. It needs to be, it could pretty much be anything, but you will notice here that there is this non-exhaustive list to sort of give you a sense of what that sign might be. Words, including personal names. I mean, words are pretty typical. It could be your brand name, for instance, or your company name. Designs, letters, numerals, colors, sounds, or the shape of goods or their packaging. So this is very interesting, right, given what we've just discussed, what you've just seen in the taxi case. No one is saying that you can't have a shape, but the circumstances in which you can have a sign that is a shape are fairly narrow, and we'll look at that exclusion a little bit later. But at least initially in step 1, you can seek to trademark a shape. You can actually pass over that hurdle. So you'll need a sign. So this is step 1A, I guess you could call it. Step 1B would be, well, can you actually represent that sign on the register? So, I don't know, has anyone gone and searched the UK trademark register just to see what that looks like? Yeah, so you can kind of see there that, of course, you need to be able to represent it. When you open it, right, you can see someone has the picture of their logo, or it has the words. So you need some way of being able to represent what your sign is. This makes sense because, of course, people who come after you should be able to search a trademark register and know that they're not treading on anyone's toes. And point C, I suppose, 1C is, well, can this sign actually distinguish your goods and services from that of another trader or another undertaking. At this point, we don't really deal with distinctiveness in step 1. At this point, arguably, I suppose, anything could be distinctive. But it becomes supremely important in step 2 in relation to the absolute grounds for refusal. So just for a little bit more detail, this is just the same point being made about representation, but this is in the EU TMR. Basically, you can do anything as long as it can be reproduced on the register. So to look at these sort of different points about signs and sort of subject matter in a bit more detail, I think it's worth remembering that the old trademark rules remain relevant because they still sort of give us an indication of what a possible sign might be. So does anyone know, actually, just from your reading, what this was about? This particular case. If I say the words balsamic fruity with a slight hint of cinnamon, anyone?
First smile, but
Yeah.
it won't apply to a smile trademark.
Yeah, so this is about, you know, will...
Smile can be.
Yeah, so a smell could be a trademark. The problem is that the difficulty that you're going to have, it can be, is how you're going to represent it. And what the Siegmund case, or the so-called Siegmund 7, and I think I should probably give a prize to someone who could name sort of all 7, just sort of off the top of their heads at this point, is still sort of relevant. Although we no longer have a graphic representation requirement, it does still give us an indication of what we might need in order to be able to accurately represent our sign in the register. And you see it here, it needs to be clear, precise, self-contained, easily accessible, intelligible, durable, and objective. So if you know anything in terms of any cases relating to representation, you should really know the Siegmund 7 because they continue to be relevant. So again, the court says, well, you can have a scent as a trademark. The question is, can you represent it graphically? This is not necessarily going to be enough because I don't know about you, but I certainly wouldn't know how that smells, right? Unless some of us are chemists and we would sort of just know. This maybe is a bit more helpful, but obviously, you know, you need to be able to tell other people what it is that you're actually claiming. So scent is one of the difficult ones. In terms of subject matter, we saw in section 1 that you can register colour as a trademark. Now, we're not going to, well, we'll focus a little bit on colour. This is just as an example. In relation to orange, we'll look at some of the chocolate disputes. But here again, you would need to identify the colour and you would need to represent this colour somehow on the register. So probably you would want to provide a sample of the colour and some kind of description. So people should be able to know what your colour is. Yes?
Can you make the simple color or is it a combination of the different colors?
It could be a combination of colours. Yeah, that's a good question. So often problems arise around the use of one colour, but absolutely you could have a combination. It might be, say, that you have stripes, or you have polka dots, or in fact you just have 2 colours that you use as part of your branding and you want to register both. Yeah?
When I looked at the trademark registry, I didn't see anything that wasn't black and white. So.
Oh, that is interesting. So do they have it somewhere else is the question, or are they just going by the description, like the actual, do you know when they have like the colour numbers?
Mm-hmm.
They will give those instead.
Yeah, maybe, but I think it wasn't really descriptive as it would have been if it was just the orange or green.
Yeah, so actually, this actually raises sort of an interesting question, doesn't it, about the register? So it is, things are represented on it, but on the face of it, you can't necessarily see the thing that they're claiming sort of immediately. Because I agree with you, you would expect that if you put in orange, that the thing that would hit you immediately was, here is a little square of orange. but it isn't. Yeah. So something like this, which you would expect. So in this case, this is, so I'm going to give examples that are variously sort of related to chocolate, because the chocolate companies are sort of quite helpfully litigious for us under these circumstances. And there are a number of, I'm not going to look at them in detail, but a number of chocolate disputes relating to Cadbury and Nestle, but in particular Cadbury attempting to register the colour purple, which they have, but only for very particular products. So you can't just have sort of purple generally, but you can have it sort of in particular classes. It's also quite helpful, so you can see purple, purple. I mean, you've probably seen these in the shops, right? The Cadbury, they're fairly sort of common chocolate bar. It doesn't mean you can sort of use it for everything. But these cases are also quite useful as examples because I think they demonstrate the various overlaps between the different grounds. So first of all, colour, often shape, often the question of later on, you know, whether it's sort of distinctive at all. So just to give you an idea of it, there are lots. And I'm pretty sure we're sort of not at the end of these yet, but there are quite a few of these in relation to sort of the purple cases. So the thing that I want to focus on is not perhaps the ins and outs, although obviously feel free to to read all of them. I think that this is probably the important thing to take out of it in sort of this part when we look at sort of step 1, which is around the sign. And it's around this question of, well, in what circumstances can a colour be registered as a trademark? The answer turns on 2 legislative requirements, whether it's a sign and whether it's graphically represented. Remember, that's the old requirement. We would now read into this, whether it's representable on the register. What the court points out, which is also relevant, is that this could be problematic, especially if they cover a multitude of different visual forms. Why does that matter? Well, it matters because you should be able to communicate to people how your actual trademark is being used and sort of where. Now, you'll see in, so say the Louboutin case, they were very clever about precisely describing where they were putting their colour, but without inadvertently seeming to claim for a shape. I think it's sort of a really clever bit of specification. So this is sort of the the basic outline of step 1. Yes.
I wanted to ask if Louboutin did the trademark, like the red sole, just for the shoe, or is it the combination of red and black? Because I've seen a lot of bags, for example, like this, shoppers.
Yes.
And the inside is completely red. And the first thing you think of is Louboutin because you see this red like thing.
Yeah, so this
so
is
what is their trademark? Is it just about the shoe or is it the red?
The trademark was as applied to the sole of a shoe, except the thing that you're describing is actually the power of their branding. That, right? Because I agree with you. When you see something, especially when it's a fashion item, and you see that sort of particular combination of red and black, you're like, oh yeah, I know who does that. So they end up actually, sort of consumer-wise, the power of that particular mark is much greater than the very narrow thing that they actually have the mark for. So yeah, this is a sort of a very good example of that. So this brings us to this question of sort of step 1. If you have valid subject matter that's representable on the register, you then, step 2, check against the absolute grounds for refusal. And just repeating the summary from before, these are some of our absolute grounds. Now, it's worth just mentioning at this point, perhaps, I mean, I guess you could tell me, in fact, no, I'm going to ask you, what do these grounds have in common? Think about this in the context of the rationales for trademark protection. What do these have in common? Let's have someone from the middle of the room. Anyone?
confuse the customer. Make the customer confused because the trademark must be different from the community. It actually, if this have these features, it actually same to the community itself.
Yeah, so quite a few of these, and in particular, I think in relation to shapes, you need to be clear what it is that you're communicating to the consumer, and it can't be the actual product itself. All of these need to be able to act as trademarks that are badges of origin that both, enhance consumer welfare, if we think about the rationales for trademark protection, but also enhance competition. So ensure some kind of fairness between different traders. So nobody is sort of getting some kind of, say, unfair competitive advantage by being allowed to prevent other people from using, say, a particular shape. Especially, by the way, if that shape has a technical function. Why? Why is that the case? Have you done patents yet? In any other class? Yes? Right. Why then wouldn't you be allowed to, we'll come back to it, but why wouldn't you be allowed to have a trademark exclusively for a shape?
Because with the thing with the patents was that it has to be a novelty and a shape. I mean.
Yeah. So exactly. The patent protection is quite stringent. You get a monopoly for something that's both new, there's novelty, isn't obvious and has industrial application, and then you have a very strong monopoly for 20 years. If you could get a trademark for basically criteria that are much, much easier to meet than that, you could get a monopoly basically forever and stop everyone else from using it. So fundamentally, there would be sort of an imbalance within intellectual property law. Okay, so looking at some of the examples here, beginning with shapes, because this is frankly where a lot of the excitement is, as you saw sort of in the London taxi case. Obviously I use the word excitement sort of quite loosely. Section 3, subsection 2 of the Trademarks Act identifies the scope of this exclusion. Just remember, at step 1, you can register shapes as a trademark, but not if it's exclusively, so this is our sort of important word here, not if it consists exclusively of the shape or another characteristic which results from the nature of the goods themselves, for example. By the way, this was inserted into the Trademarks Act on the 14th of January of this year. So this is bringing the UK up to speed in relation to harmonisation. That's the reason I've highlighted it. So you won't get it exclusively for the shape, and this is why we've just discussed patents. You won't get it if the shape or another characteristic is necessary to obtain a technical result. That also makes sense because then you could actually prevent other people from actually producing goods, right? If you think about this from the perspective of the trademark functions, this makes perfect sense, this exclusion, because the whole point is that it's a badge of origin that you affix to goods or services that tells you who the producer is. It is not for the protection of the goods themselves. I mean, this is sort of the fundamental distinction between, say, trademark law and patents or designs, etc. And then finally, and this one can be a little bit more tricky, you cannot have a trademark for a shape or a characteristic which gives substantial value to the goods. Yeah, this is one I've always found interesting because when we think about what we've looked at in terms of branding, you may well be buying it for that reason. But in terms of the exclusion, if it is the sign itself that gives value to the goods, it's not actually really functioning as a sign, and you're not going to be allowed to protect it. So let's have an example. So this is in the TMR. Here the question is about this three-headed shaver, and this is we're looking at shapes here, but this is actually also about acquired distinctiveness. Is this distinctive? Is this particular shape distinctive? Is sort of the question here. Or, I guess even if you don't know anything about the case, should you be allowed to register as a trademark this particular shape, the three-headed shaver? What's the question that we should be asking?
Whether it's that shape just for function.
Yeah, exactly. So, is it just performing some kind of technical function, in which case you're trying to trademark the product, or can it actually act to distinguish your goods and services from those of another trader? Now, the court says in principle here, in this particular reference, that in principle, anything that is assigned could acquire distinctiveness. You could have a particular shape that acquires, also that acquires distinctiveness, and it could be used. However, it cannot be solely a shape that obtains, say, a particular technical result. So this is the way the court describes it, saying, the shape in question must simply be capable of distinguishing the product. This is your badge of origin alert in terms of trademark functions. Because it's distinguishing the product of the proprietor of the trademark from that of other proprietors. The court continues by saying the rationale is to prevent the creation of a monopoly on technical solutions or functional characteristics of a product. So again, just making very clear that you need it to be able to act as a badge of origin. And that brings us to, this is the case that I just mentioned earlier. The question here was, is this a shape mark, a color mark? Is it neither? So this is red. This is a picture from the judgment. And an attempt was made to say, well, actually, you can't have this trademark because you're claiming a shape. But what was actually found was that the way it was described was not to claim a shape. It wasn't exclusively a shape. If it was exclusively a shape, you couldn't have it. But seeing as they were just saying a color as applied in this particular way, you could have the color. I mean, we can probably disagree about sort of whether this is appropriate or not. But certainly they were able to specify it in such a way that it didn't actually fall foul of the three shape exclusions. Okay, what is this? Did I hear Kit Kat? Yes, it is a Kit Kat. So this is actually quite an interesting case. They've been very litigious and they keep trying, right, to register the Kit Kat. Does anyone know, sort of from your reading, why are we talking about Kit Kats in the context of the shape exclusion? Even if you didn't know anything about the case, does the Kit Kat fall within, just leaving aside the case, just looking at that picture, you are presented with that picture, does it potentially fall under any of these exclusions? Anyone? Possibly, right? I mean, the courts do say later on, they're saying, look, this is the actual product, right? Also, it's in wrapping. So it's not like you can even see it when you're sort of, walking around the supermarket or whatever and you're wanting to take it. So I think, when this is looked at in the case, this is a particular exclusion saying, well, this is just the good. the one that I've always sort of found sort of interesting is it also a shape that's necessary to obtain a technical result? What's a technical result?
Just generally, or in this?
What's that?
Just generally, or in this particular?
In this particular, so what is the technical result that's obtained by this shape?
Easy to snap.
Yeah, exactly. You can snap it. So it's sort of, I don't know, this is sort of perhaps stretching technical result, but it doesn't seem sort of unlikely to me that this is something that's also obtaining a particular technical result. So there were attempts made in this case to sort of lead evidence. You will often see sort of in relation to focus groups, etc., around, do people identify this as a KitKat? And actually, I think a majority, not a massive majority of respondents did actually identify this as being a KitKat. And there were these, if you read the case, there are all these sort of interesting exchanges where you can just sort of imagine someone sort of presenting this KitKat shape to someone and saying, please look at this picture, please let me know when you are ready to continue. What, if anything, can you tell me about this? And so if someone says, well, it's a chocolate, but they don't say that it's a KitKat, then follow-up questions are asked, well, what else can you tell me about it? If they then mention that it's a KitKat, they're then asked, you mentioned this branding, why was that? So trying to sort of get a sense of what it is that consumers were thinking about the product in an effort to demonstrate that actually it was this shape that had come to be associated sort of in the consumer mind with the producer. In other words, that this particular shape was now functioning as a mark, something that was distinguishing goods.
I worked for KitKat as a promoter.
Oh, wonderful. How did you promote KitKat?
That's the thing, I was wearing a red shirt because they also have this red label.
Yes.
So I was wearing the red shirt with the white text on it, and I was asking the people, like I'm working at the airport, so I was asking the customers for if they want to try chocolate, and then my supervisor came to me and she said, no, that's wrong. You have to ask them if they want to try a KitKat.
Oh,
So I wasn't even allowed to say chocolate. I had to say KitKat.
Yeah, which makes sense that if you're trying to associate a particular chocolate product in the public mind with that particular phrase,
so they would know just what I tried is KitKat.
Mm-hmm. Yep.
Yeah, that was.
This is actually an excellent sort of practical example of branding in action.
That's why, like, I
Yes.
also work for Chanel and Yves Saint Laurent and the others. That's why
Yeah, but you can see that this is how, but when we go back to sort of the creation of brands, this is how it's created. It's created through that relationship between the particular trader and the consumer. And it doesn't just sort of happen by accident. Very often there are actual people who are making that connection happen, right? It's not just advertising. So that's an excellent example. Thank you.
the have a break, have a KitKat, the text.
Yes, so...
Is that copyright or what?
It could be. We're not doing that
It's
in
a
this class.
slogan. Like,
Well, it's a slogan, so it could be. So after InfoPark, I suppose in the context of copyright law, you could argue that it's. I mean, it's short text like headlines. Newspaper headlines can be copyright protected, so it possibly could be. I doubt it, but I suspect that they also have the trademark for that.
so in general, like slogans are trademarks?
They can be
Okay.
if they meet the requirements. No, absolutely. So the word kit or the expression KitKat will be a trademark. They may even have red as a trademark. What they don't have is the shape of the KitKat.
So you don't think it's have a break, have a KitKat? Let's say someone says, have a break, have a Twix. Is that allowed?
Well, no, the question then would be is if they had a registered trademark for the slogan, have a break, have a KitKat, and someone started saying, have a break, have a Twix, would that be an infringement?
Yeah, that's...
Chances are that it would be because they're in the same class, would be my guess. But I don't know because no one, I mean, you just wouldn't do it unless you were, oh, is it McDonald's and Burger King who sort of tend to annoy each other in that sort of way, by sort of seeming to sort of push the boundaries of, I'm actually going to use your trademark on purpose and sort of generate interest that way.
Yeah, well,
So
one has
possibly
the
it would be-
McChicken and the other one has the McRoyal or whatever.
Yeah, it was
Actually
something
the
like
same
this.
burger.
I'm fairly sure, I don't know, but I'm fairly sure there's actually a case that they tried to trademark just have a break and it was refused.
because they were just trying to do it just for the...
Yes, the full
Yeah.
have break, have a Kit Kat, they do have, but they can't have.
Oh yeah, no, have a break, because otherwise, I mean, what's the problem with that, right? Is that what nobody else could use it, say, in an advertising slogan relating to snacks, which really I think would seem a little bit harsh. So in this, so here we have, just on this issue around shapes, they're saying, well, why does all of this matter? So there's this link again between the shape and its distinctiveness. And again, because everything comes back to the trademark functions, the point is that it's not something that members of the public are likely to take as being a badge of origin. Rather, they might simply regard the shape as a characteristic of a product of that kind, or they might find it brings to mind the product and brand name with which they have become familiar. It's quite a fine line though, right? Because I mean, you all sort of identified it immediately as a Kit Kat. It's not really, your immediate response wasn't chocolate, it was Kit Kat. So it's sort of, it's quite interesting, I think, to suggest that actually no, the thing that you're saying is really, you know, that it might not be distinctive. I am, however, quite taken with the idea that, of course, it's in packaging, right? So you're really not using it as a badge of origin. It doesn't seem particularly like this was an unfair result for Nestle. Okay, so that's shapes and chocolate. I want to move on to the descriptive grounds and look at a couple of cases there. Here, we're now in section 3.1, and you will see that you can't register a sign that is descriptive of the goods. This makes sense, obviously, in the context of the functions, because if it's simply telling you what the good is, it's not acting as a badge of origin. Now, this isn't to say that you can't acquire distinctiveness notwithstanding that it's descriptive, but obviously that's going to be more difficult. Does that make sense? So you could say, well, at that initial point, you just had something that was descriptive, but it came to be associated with your product in such a way that actually it was fine. So it's possible. Right, who are our German university students? Wonderful. Can someone pronounce the name of the lake for me?
Chiemsee.
Excellent. And what associations do you have with this particular lake? I have not been, I only know this from the case. Anyone? What?
It's very large.
Excellent. Is it quite pretty? Do you hike there? Do you feel healthy if you go there? I mean, what are sort of the associations with this lake? This is actually genuinely relevant to this case.
It's in Bavaria, so maybe we never went there.
Okay.
You can drive by on the railroad.
Okay. Yep. But I mean, I'm assuming that it's like everyone would know that it's there, right? It's not a small lake. It's not one that someone's likely to forget exists, right?
It's a really, really big lake. I think the second largest in Germany, and it's really popular for like outdoor sports and waters, water activities and all that stuff.
Very good. Okay, so precisely this point about outdoor sports is why when it comes up to this is that, you know, should someone be able to, so this is a preliminary reference from the German court, so I'm obviously just not obviously going to attempt any of the sort of the German sort of the German law in relation to the sort of the public interest, etc. But I think it has sort of quite important, there's quite important sort of overall arguments here around, should you be allowed to use the name of a place on your product? Is it descriptive? So here we have two manufacturers of clothing. I'm assuming it's outdoor clothing. Do you think they should be allowed to use the name of this quite famous second biggest lake?
Yes.
Mm-hmm.
Because there is also a boxing event called Everest. Same thing.
Oh yeah, that's actually, that's a good example actually.
Yeah.
So you might be able to use it. And the way you might decide on any particular facts, what we see from this case is that you need to decide whether it ought to be left free for others to use. So you may be allowed to use it, but not in such a way that would suddenly prevent others from using it in a situation where that would be helpful. So specifically, in terms of the policy, in this case of the trademark directive, you would ordinarily refuse registration on the basis that other people should also be allowed to use the name of this lake or a mountain or whatever it is, unless you can demonstrate that this particular name of the lake or of another place has acquired distinctiveness. So that actually, perhaps you got in there first or whatever it is, but consumers now associate your, say, clothing company or outdoor sports company or whatever it is with that particular place. So this is what the court has to say about it, saying that it's in the public interest that these names remain available because they may indicate the quality or characteristic of the goods. They may influence consumer tastes by, for instance, associating the goods with a place that may give rise to a favorable response. I'm assuming outdoor sports, etc., etc.
There's something coming up to my mind. There is a restaurant on Byers Road called Little Italy. So
Right.
actually, are they allowed to? I mean, they're obviously allowed because the restaurant is there, but
Oh yeah, so
how is that?
basically,
Because I would assume, wow, they have like good Italian food.
okay, so in fact, you can have anything you want as an unregistered trademark.
Oh, but
Assuming-
okay, they have it, but it's not registered.
It's entirely possible.
Okay.
I think it also has some more relevant to the geographic indication.
Yes.
So if we use it as a trademark, it might be constitute unfair competition.
So we're not actually dealing with geographical indications until the final substantive seminar, which is next term. But yes, you won't be allowed to, in particular, register your place name if it is already a geographical indication. And the GI protection is obviously quite useful. As far as I know, and perhaps German colleagues can correct me, I don't think this lake is a GI, but we could search sort of the GI register to check. But if it was, yeah, they would definitely not be getting this because it exists already. Okay, so yes.
I think the court think the public associate the mark with the trademark owner, not with the geographic area. So I think the relationship with the trademark is with the products, not only the geographic. Maybe the geographic only shows the original of the product, but what important is the quality of the goods.
Yeah, exactly. So this is where the acquired distinctiveness comes in. You can't have descriptive marks, but you may be able to show that in fact they're associated precisely with this product. Yes. So it's saying you can't have this, but here's a sort of get out sort of clause, like an exception, if you can make it. Now things get a little bit more interesting perhaps in the context of particular names. And I want to contrast two cases here. The first is the baby dry case for nappies, for like babies' nappies. Is baby dry descriptive of nappies? You can either tell me what you think or what the court said if you happen to know. Anyone?
Can you repeat your question?
Is baby dry descriptive of babies' nappies? Were you first? Mm-hmm.
Yeah, I think the court thing it only describe I think the name or the function I forgot that, but it only describes that, so it won't be registered.
You would think so, wouldn't you? Instead, what the court says is, oh, this is a lexical invention. It's a lexical invention. The way you're combining the words baby and dry, I think it's all to do with the hyphen. I'm not quite sure. That actually, that makes it enough to not be descriptive. It can actually act as distinctive, notwithstanding that you have the word baby and dry, and in fact you're selling nappies, which is quite, I think, sort of remarkable. Yeah, and which is why I'm saying I want to contrast to the second case. Is double mint descriptive for chewing gum? chewing gum is mint flavored for the avoidance of doubt.
Yes.
Yes, it is. So, what is the difference between baby dry as a word and double mint as a word? You know, so this is where things sort of perhaps get a little bit interesting, because it doesn't seem. Is the difference just? Is it the particular words? Is it the fact that there's a hyphen? Is it? I'm not quite sure, because it's not like you would ordinarily refer to chewing gum as sort of double mint or something like that. So that brings us to, so this is what the court says about it. A sign must therefore be refused registration if at least one of its possible meanings designates a characteristic of the goods and services concerned. So okay, so double mint is saying that they're minty chewing gum, but equally, I suppose we could argue that baby dry, by using the word dry, is actually telling you something about the nappies. So I think perhaps these don't quite match up. What was that?
And they register these words? Because these words are more likely to be used by the competitors as well. Because they are describing the product itself.
Yeah, so actually,
what I mean?
yeah, so that raises actually the separate issue, although we're not dealing with it directly here in relation to descriptiveness. This raises a separate issue that you won't be allowed to register signs that are customary in a particular trade. So if particular traders, whether it's sort of car repairs or chocolate or fashion, need to be able to use particular words, you won't be allowed to register them, because of course it's going to be anti-competitive if you're stopping other people from using them. Okay, oh, this is terrible. We're about to run out of time just as I'm about to get to the interesting bit about public policy. I propose that I leave it so we can actually give it some attention, but this is one of the absolute grounds, and so I will just say quickly that even if you meet all of the other requirements, it may be that your particular sign that you're trying to register is, in some sense, contrary to public policy. So, for instance, a very basic example would be that it's likely to be offensive, or racist, or in other way likely to sort of offend sensibilities. And the question that was asked just very quickly was, we will come back to this, but around whether you could subsequently challenge it. I think you probably can. I think this is the form that you would use. This was your question, I think. I think that you may be able to, what you would do is subsequently argue that the registration of it was invalid. You would need to give reasons. But I think it would be possible. I don't know actually whether it would be successful, but you would be able to make an application to register, to declare that registration invalid. The reason I think that you would need to use this process rather than revocation is that revocation, which we'll do in a couple of weeks, has a much narrower, more specific range of circumstances in which you can use it, like non-use. Really, if you want to use, as far as I can tell, there's not actually very much in the public policy grounds. You would sort of need to use the nuclear option, which would be seeking a declaration of invalidity. So I'm just going to sort of let that hang there so we can pick up on this in 2 weeks' time. Obviously, if you have any questions, send them to me. It is always very nice to receive sort of some of these sort of, particularly interesting questions that sort of strike very much at the heart of what we're trying to do. So if you have questions, feel free to send them and we can discuss them in class. If you want to find out the answer sort of straight away, you can come and ask me, but we will we'll do it again in 2 weeks. Okay, don't come next week, it's a reading week.